So welcome my dear students, welcome back for a new chapter, a new work on the bank or the financial transactions in the law and how it is determined in the law. And how it can be arranged in the law. This about the bank credits or the bank transactions. Bank transactions include, as example, the way to pay, installment or cash. You use checks, you use bill of exchange, you use what are you using in your business? And what about the electronic commerce transactions? And this is very important, the electronic commerce or commercial transactions. We have the credit card and the debit card, and this is the first point, dealing with the credit and debit card. The electronic transfer of funds where e-banking is available has greatly reduced the use of checks. So using the electronic payment, the e-transfer, and it reduced too much the use of the checks. The use of credit cards and debit cards in financial transactions has grown enormously in Canada. Now, these sentences, I just want to enlarge it so everyone can see. The electronic transfer of funds where the banking is available has greatly reduced the use of checks. The use of credit cards and debit cards in financial transactions has grown enormously in Canada. Although a business would not usually use a credit or debit card for the purchase of a major assets or large-scale inventory, they are used regularly for minor everyday business operations. Like all of us now, we use the Visa and the American Express, and we use the ATM machines. All those types, we call it electronic transactions. Okay. The Federal Bills of Exchange Acts say a bill of exchange, about the bill of exchange, which was used enormously in the past, is an unconditional order in writing addressed by one person to another, signed by the person giving it, requiring the person to whom it is addressed to pay on demand or at a fixed or determined future time, a sum certain in money to the order of a specified person or to bearer. This is the bill of exchange, and it's like a check. It's a way to settle the payments, one of the means of settling the payments. Credit cards and debit cards are not bills of exchange. So in that case, we cannot say the credit card and the debit are bill of exchange. No, they differ than the bill of exchange. So this is the part which I want to enlarge for everyone to know, including the bill of exchange, BE, we call it BE definition or bill of exchange, and its usage and who is directed from whom to whom and for what reason, for settlement of payment. And it can be to the bearer, specified order specified to the bearer. Okay. Or to a specific person. Okay. Consequently, the Federal Bill of Exchange Act not govern the use of substitute for money. Use it as a substitute for money. Okay. This was about the continuous growth of use of credit and debit cards in Canada resulted in the creation of federal government voluntary code of conduct for the credit and debit card industry in Canada. The code purpose is to the promotion of fair business practices. That's very nice. And increased disclosure with the goals of helping both consumer and merchants understand the costs and benefit associated with the use of credit and debit card. So this is to show the importance of using debit and credit card. The code or the Code of Canada applies to both issues issuers and acquirers participating in payment card network. So it is like to encourage the payment with credit card and debit cards. Now we'll see about the payment cards networks that cover the electronic payment. The federal government payment card network defines payment network cards as an electronic payment system used to accept, transmit, or process transactions made payment card for money, goods, or services, and to transfer information and funds among issuers, acquirers, merchants, and payment card users. So this is the use of cards. How can we finance operations? How can we get the money? Finance operations means how to get the money for operating our work, for operating our business, how we will get the money to operate our business. You need to determine your short-term money capital needs. So if you need your money for a short term or for a long term, and how much you need, as well as your long-term capital needs. So either you have to decide what you need is for short term or for long term. You need to determine your short-term money capital needs as well as your long-term capital needs. Then you can consider whether to finance your business operations through debt or equity. Okay, so what do we mean by when I finance my needs with debt, and what's the meaning of finance my needs with the equity? Debts or equity? Let us go for it now, debts or equity. So debts financing involves borrowing the capital for a period of time. So I will borrow the capital for a period of time and repaying the loan plus the interest charges. That's fine. Now I took as a loan, or I borrow $1,000, I will return it 1,500. I took $1,000 from the bank, I will return it $1,500. So this we call it the interest. This we call it the interest. So we will pay the origin plus the interest of the money. We will pay the origin plus the interest of the money. Okay. How this help? Cool, that's fine. But the equity financing means what? Equity financing means we can achieve the equity financing through the sale of shares. When we sell shares, when we sell shares, the shares are the stocks or dividend. Those are called shares in your corporation to investors. When you sell it to investors, this we call it equity financing. So one of two things: I will borrow from the bank, or my company will issue stocks. This is the equity financing. So we have debt financing, and we can also have equity financing. Those are the two resources to get the money. Those are two ways, and they've been arranged in the Canadian law, how to get them, how to issue them. Okay, the guarantee. What do you mean by the guarantee? Another form of security for a loan involves a third party acting as a guarantor for the debt. The guarantor agrees to pay the debt if the borrowers default in making the payment. So the guarantor agreed that you took money from the bank. I went as your guarantor. Means if you did not pay, I will carry the responsibility and I will pay instead of you. Again, you went to the bank to take money, to borrow money, and you took me as a guarantor. Okay, if you didn't pay to the bank, then for any reason you went for a bankruptcy or whatever, then the bank will come and ask me for the payment. The bank will ask me for the payment. The guarantor, the guarantee must be in writing, and until default occurs, there is no liability on the guarantor. So the guarantor's liability starts when there is default, or the person who borrowed the money is not able to pay anymore. In that case, the guarantor is the one who will pay instead of the guarantee, or the person who took the money. The person who owed the money or who lent the money, then the guarantor will pay for him instead of him. Status of frauds. Status of fraud. We'll know something in the statute of frauds and how it is helping in the transactions, the monetary transactions in Canada here. Each province, like we see here, each province and territory has some of the statute of frauds legislations that requires any agreement, see that, requires any agreement in the nature of a guarantee to be in writing and signed by the guarantor. So no guarantee agreement in verbal. All the guarantee agreements must be written, it must be written in writing and signed, written and signed. Alberta is unique, and we'll see why Alberta is unique. In Alberta, Guarantees Acknowledgements Act set out the specific process requiring guarantees to be in writing from any person other than the corporation. As well, a lawyer must certify that the guarantor is aware of the guarantee and understand the obligation. This is for Alberta regarding the guarantee. Now, we have also something, we talk about the equity financing. This means that you will issue stocks, you will issue shares or stocks to expand. When you need money, you will issue more stocks. The alternative debt to debt financing means that you go to the bank and take money and return the money, return back the money plus the interest, is equity financing. So the equity financing is another alternate for debt financing, which involves selling shares to investors. So equity financing means selling, like I told you, selling shares to investors, okay, who receive an ownership interest in the corporation. This is the other way. And now we will come to something we call it crowdfunding. What is the crowdfunding? We knew now two things now about sources of money when we need money in our corporation. Is it by lending from the bank and returning the money with interest, or the other way is to issue stocks? Now let us go to crowdfunding and know what is the meaning of crowdfunding. Crowdfunding is a practice, let me take this paragraph, is a practice that grows rapidly, particularly as a popular way to fund a project or ventures, such as a startup company. Yeah, a startup company means a company which will start working by raising many small amounts of money from a large number of people using the internet. This is crowdfunding. So this is the specific. People collect in the internet and they work on it. The practice that has been growing rapidly nowadays is more, particularly as a popular way to fund a project or venture such as a startup company by raising many small amounts of money from a large number of people using the internet. So the people on the internet are the one who do it. They increase the amount of money for a company and a startup, and that we call it crowdfunding. 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 Okay. According to the Canada Revenue Agency, depending on the circumstances of fundraising and the facts, the money raised could be seen as a loan, a capital contribution in the form of equity, a gift, business income, whatever, or some combination of these elements in the context of business. If the crowdfunding is for a new product or service, or project, it would likely qualify as income for tax purpose. So it will be also within the consideration of taxes. In Canada, both private and public companies are able to raise funds by crowdfunding to maximum amount of $1.5 million in any 12 months period. Again, this is the most important part in all this. What is the application of the crowdfunding in Canada? In Canada, both private and public companies are able to raise funds by crowdfunding to maximum amount of $1.5 million in any 12-month period. So you can use the crowdfunding to raise up your capital of money, your money into $1.5 million within 12 months of business. This we call it crowdfunding. That's about the regular provinces, about the crowdfunding. We came now maybe to the most important part, insolvency and bankruptcy. Bankruptcy, when someone goes on a fact that he's not able, he failed and he lost his money in the business and he came to an end and he got no any money now to pay for the debtors. This we call it the bankruptcy. Okay. The fact that you owe more than 1,000 and have not been able to meet your payment technically means that you are insolvent. Okay, this is the first point I want you to know. I'm not able to pay my obligations. The law relating to insolvency and bankruptcy in Canada are aimed at preserving the assets of the debtor for the benefit of the creditors. So the bank will hold the assets and see how much it will be, the amount of it, and that will go for the creditors. Or as example, I am in a bankruptcy, means I don't have money to pay, but I have a house and I have a car. So the bank will put his hand on the, or seize the house and the car, and it will probably might solve them in favor of the people to whom I have to pay the money, or the creditors. The creditors are the people to whom I have to pay the money. Okay. Okay. So the bank put the hands on the positions of the debtor in favor of the creditor, so it will return back to the creditor. Okay. We have here, we can't wait till we have to talk about the Bankruptcy and Insolvency Act. The Federal Bankruptcy and Insolvency Act governs all insolvencies and bankruptcies in Canada and creates a process that can be applied to insolvency situations for almost any form of organization, business organization, individual, partnership, and corporation. It details the responsibilities and rights of all parties involved in the process. The superintendent of the bankruptcy, the official reserves, who represent the superintendent of bankruptcy, the court licensed bankruptcy, trustees, the debtor, and the creditor. So this must be determined very well. Okay. Unlike the United States, Canada has no separate bankruptcy court. We don't have a bankruptcy court here in Canada. There is no bankruptcy court. There's no court for the bankruptcy. Okay. The act gives jurisdiction to the provincial courts over which federally appointed judges preside. This is what we want. This now is what we want to read. This is the core of our work. Under the Bankruptcy and Insolvency Act, a business is insolvent if it owes its creditors $1,000 or more. But this is not, a lot of companies are having this condition. They owe the others, they have to pay to the others 1,000 or more, but is unable to pay this 1,000. Is unable. I don't have money to pay for you. I don't have money. Yes, I owe you, but I don't have money to pay for you. Meets its obligation generally as the come due. So I won't pay for you on the date due. The acts allow debtors to make a proposal to their creditors to restructure their debt and try to reach a compromise solution. This can be done informally through agreement. This can be done informally through agreement. Okay, this can be done through agreement, like we said, informally, but not in a formal way. Informal, they sit at the table and try to solve the problem, an agreement between the debtor and the creditor. So they will sit with each other. I don't have money to pay. Okay, can you make it extend the time period or whatever of payment, that did due of payment? Then the debtor's notice of intention to file a proposal creates a 30-day stay period that can be extended up to 6 months against unsecured and most secured creditors. A trustee in a bankruptcy is retained to work with the debtor to prepare the proposal, which is then sent to the official receiver for approval. If approved, the proposal is sent to the creditors who vote as a group to accept or reject the proposal. If accepted, the debt restructuring under the proposal is binding on the debtors and is unsecured. Creditors creditors still retain the right to seize and sell the secured assets. However, the debtor does not go into bankruptcy as long as it lives by the terms of this proposal. As long as this proposal is there, there is no bankruptcy, and that's the meaning. So like the bankruptcy will start when everything is collapsed and I'm not able to pay 1,000 or more in the upcoming period or in the date due for you. I took from you $1,000 or more. I cannot pay them anymore. What are the courts? Like the United States, we said, United States, they have courts only for the bankruptcy. But here, no. The position in Canada is different. Courts for insolvency proceeding. Some provincial courts have established a commercial court branch to deal with insolvency proceeding. In Ontario, a specialized commercial list branch was established for this purpose. So we don't have here in Canada a special courts for the bankruptcy. That is let us see this. Any payment or transfer of an asset that take place within certain defined period prior to the bankruptcy that impact on the claims of the creditors can be challenged by the trustee. In a bankruptcy, the trustee sell the remaining assets, establishes the priorities of the creditors' claims, and distribute the proceeds. Okay, we have three kinds. Let us read this. There are three basic classes of creditors in a bankruptcy procedures in priority. There are the secured creditors, the preferred creditors, and the unsecured creditors. So let us see the difference between them. The secured creditors, this class of creditors may take possession of the secured goods and sell them to pay the debts. Any surplus funds are given to the trustee. Okay. or if the proceeds are not enough to eliminate the debt, the creditor rank as unsecured creditor of the balance. The second kind of creditors, we call them preferred creditors. This class of creditors include, among others, the trustee in bankruptcy for the fees involved in the bankruptcy process, the funeral expenses, the landlords for up to 3 months, back rent on leased premises, and some employees' claims for unpaid wages. The final one is the unsecured creditors. This class of creditors shares in total remaining. Class of creditors share in total remaining, right? Proceeds from the sales of debtors' state after payment of the preferred creditors. Okay. Each unsecured creditor receives a percentage of what was owed to it. That's all we have for the moment regarding our work here. Shall see you again. Thank you so much. Enjoy your day. Have a very great day. Thank you. And see you in the next lecture. All my best wishes. Thank you. Bye-bye.